everyone, welcome to iExamB's Legal Beat. I am Neha, your law faculty. आज मैं इस वीडियो में कंटिन्यू करने वाली हूँ हमारा जो जुडिशरी का मेंस आंसर राइटिंग डिस्कशन सीरीज चल रहा है उसके रिस्पेक्ट में I'll be moving ahead. But before that, do remember to subscribe to our channel, press on the bell icon so that you can stay tuned and stay updated. इसके अलावा आप हमें कांटेक्ट कर सकते हो इस पर्टिकुलर ईमेल आईडी पे या आप हमें कॉल भी कर सकते हो इस नंबर पे अगर आप कोई भी क्वेश्चंस, क्वेरीज या डाउट हो और आप उसको क्लैरिफाई करना चाहते हो तो आप हमें कांटेक्ट कर सकते हो. We are there to help you out, to guide you. Apart from that, do remember to visit our website wherein you will get details with respect to the various competitive exams. So stay tuned and stay updated. As I already mentioned, इस वीडियो में हम जुडिशरी मेंस आंसर राइटिंग प्रैक्टिस से रिलेटेड एस्पेक्ट्स को कवर करेंगे. क्वेश्चन नंबर 10 आज हम डिस्कस करने वाले इस वीडियो में. इसका मतलब हमने पहले ऑलरेडी 9 क्वेश्चंस जुडिशरी के मेंस आंसर राइटिंग प्रैक्टिस ऑलरेडी डिस्कस किए हैं अपने प्रीवियस वीडियोस में and that was related to different other subjects or acts you can say. आज इस पर्टिकुलर वीडियो में हम डिस्कस करने वाले हैं कॉन्ट्रैक्ट एक्ट से रिलेटेड. But before I move on with our discussion with how to write the answer, I'd like to remind you that we at iExamB, we are going to conduct a free workshop with Robin Dutt sir, who is a practicing advocate in Punjab and Haryana High Court, Chandigarh and Supreme Court of India. And he is going to be there to help you out, to guide you with respect to your various questions or queries या आपको कोई भी डाउट हो litigation से related, judiciary से related. He is there to help you out and to answer your all doubts. So do remember to register for this free workshop which iExamB's Legal Bill is conducting only for you all to help you get answered with all your questions and doubts. Now moving on to our today's discussion with respect to the means answer writing. आज हम देखने वाले हैं question related to Indian Contract Act and the question is discuss the doctrine of consideration under the Indian Contract Act. So let me tell you one thing. कोई भी आप आंसर लिखने जा रहे हो means किसी भी एक्ट से रिलेटेड हो, there are few things you have to take care of when you are going to write a descriptive answer, whether it be the Contract Act or any other law. So अब मान लो आपको क्वेश्चन दे गया discuss the doctrine of consideration. So you have to first and foremost thing which you have to do is you have to analyze the question, what it is seeking to ask you. You have to prepare a mental framework, a chronology, a sequence in which you are going to answer the question. आपको consideration से related बहुत सारी चीजें आती है, but you have to see and ensure that आप उसको एक chronology में, एक sequence में तरीके से present करोगे, not in an haphazard way जैसे हमारे mind में आ गया और जब जो आते जाएगा हम उसे लिखते जाएंगे. So you have to prepare quickly a framework with respect to that and you have to ensure कि जितने भी आप आंसर्स लिखने वाले हो उसमें ऑलमोस्ट यूनिफॉर्म पैटर्न को आप जो है रखोगे. ठीक है, तो लेट्स गो अहेड विथ रिस्पेक्ट टू इट्स डिस्कशन. सो कुछ चीजें जो आपको मैं ऑलरेडी पहले जैसा बता रही थी आपको हमेशा याद रखनी है किसी भी आंसर को करते समय डिस्क्रिप्टिव में. फर्स्ट इज यू शुड इंश्योर दैट द आंसर्स आर पॉइंट वाइज बिकॉज जब वो पॉइंट वाइज में रहता है इट इज वेरी इजियर फॉर द अदर पर्सन टू रीड एंड अंडरस्टैंड इट कंपैरेटिवली इफ इट इज जस्ट बिग पैराग्राफ. सो ट्राई एंड break down your answers as much as possible. Write them in point wise. Highlight them, underline them. Highlight the important things. अभी जो भी चीजें मैं आपको बता रही हूँ आपको ध्यान रखनी है उसको मैंने अपने आंसर में इंक्लूड किया है so that you can make out what exactly I'm trying to convey you. So point wise में लिखना है, underline करना है या highlight करना है, well framed and sequence में आपको present करना है. Apart from this, you have to provide a synopsis. Synopsis मतलब पूरी summary जो आप उस descriptive answer में लिखने वाले हैं उसका एक summary gist आपको provide करना है wherein you have to ensure that there is an introduction which is there in your answer. Then there is meaning and nature of consideration, essentials of consideration or rules governing the consideration. So this is basically you can say the body of your answer. पहला हमें क्या देना है, introduction, introduce करना है what consideration is and all those aspects we have to cover. Then important aspects related to consideration, then its definition, the case laws, the examples, all those you can include in the body to enhance your answer. So ये body में आप जैसे मैंने यहाँ 2 और 3 नंबर पे लिखा है meaning and nature, essentials of consideration. That doesn't amount कि आपको यहाँ पे उसके definition नहीं include करनी है या case laws नहीं include करना, examples नहीं. All those aspects आपको अपने body में cover up करना है and then you have to conclude your answer whatever till essentials you have provided in detail. You have to brief up, conclude that at the end. So you have to remember there should be an introduction, body and conclusion. Body में as much case laws and examples as I already mentioned you have to include. Now if we move on to the answer of this particular question we can see जैसा मैंने आपको बोला था introduction होगा. आप यहाँ यहाँ देख सकते हो मैंने पॉइंट वाइज में भी दिया है. सो दिस इज जस्ट एन आइडिया ऑफ हाउ यू शुड गो अबाउट द आंसर. नाउ लुकिंग ऑन टू कंसिडरेशन, इट इज वन ऑफ द इम्पोर्टेंट डॉक्ट्रिन अंडर द इंडियन कॉन्ट्रैक्ट एक्ट. सिंपल टर्म्स में हम इसे क्या समझते हैं? समथिंग फॉर समथिंग, एंड इन लैटिन इट मीन्स विद प्रो क्यू. सो आपने सिंपल इंग्लिश में भी बता दिया, लैटिन में व्हाट इट is actually termed as, that also you have mentioned. And for the formation of a valid contract, it is essential that there should be consideration. So for any valid contract, consideration is important. That is also being mentioned in our introduction. So this is a brief idea introduction of the topic. Then moving on to the body part. अब यहाँ से हमारा body start हो जा रहा है, जो कि आपका main है, important area है, जहाँ as much case laws and examples you can include, you have to. यहाँ पे मैंने सबसे पहले डेफिनेशन दिया कंसिडरेशन का, विच इज अंडर सेक्शन 2 क्लॉज डी ऑफ द कॉन्ट्रैक्ट एक्ट, एंड द डेफिनेशन हैज बीन प्रेजेंटेड एंड इट इज कोटेड. यू हैव टू इंश्योर कि सेम टू सेम अगर आप डेफिनेशन लिख रहे हो जो कि हमारे पेयर एक्ट में है, सो यू हैव टू कोट दैट. सो व्हेन एट द डिजायर ऑफ द प्रोमिसर, द प्रोमिसी और एनी अदर पर्सन हैज डन और abstain from doing or does or abstains from doing or promises to do or abstain from doing something, such act, abstinence or promise is termed as consideration for the promise. So यहाँ हमने define किया सबसे पहले contract act में consideration कैसे define है. Next we can see that the definition provided by various jurists can be presented apart from the Bear Act definition which is provided. So Sir Frederick Pollock has defined consideration how as an act of forbearance of one party of the promise thereof is the price for which the promise of the other is bought, and the promise thus given for value is enforceable. So any promise which is given for value, that is enforceable in the court of law. So consideration is basically what? The price paid for the fulfillment of the promises between two parties. Here the promiser is one who is making the proposal and promisee is the one who is accepting the proposal. तो देखो कितने concise, precise way में who are the two parties in that particular transaction. That also contract also we have included in a most simple and precise manner, that there is a promiser who is going to make a proposal or offer and there is a promisee who is going to accept it. So both the parties also we have defined. Thus without lawful consideration, obviously if you are entering into a contract, for that particular contract to be a valid and enforceable one, you have to ensure what? That there is a lawful consideration. An agreement cannot be held a valid and hence become void and not enforceable by the court of law. So if the consideration is not lawful, the agreement cannot be considered to be a valid one. It will be a void one and hence it will not be enforceable by the court of law. All these things again in a simple concise statement we have included. Then consideration can be understood with simple example. अब हमने यहाँ पे एग्जाम्पल देना है, wherein you can provide an example with respect to consideration, that there is a person who is offering something to sell to the other, there is the other person who will be accepting the offer, and so what will be the consideration in that given example where there are two parties in that particular contract transaction, wherein one is offering to sell his laptop to some other person at a certain price and the other is accepting the offer in the absolute sense. And so in the context of this particular contract example which we are stating over here, the sum of rupees 50,000, that is consideration for the promise of the promiser, okay, while the laptop is the consideration for the promise of the promisee. So all these aspects, elaborations we have included. अब यहाँ पे already क्योंकि हमने parties को define कर दिया था, one who is accepting the proposal is promisee, one who is giving the proposal is the promiser. So it is very evident and there is a connectivity in your answer, क्योंकि आपने पहले ही parties के बारे में बताया, validity of agreement कब होगी, जब lawful consideration का ये सब बताया, और जब आपने example दिया so उससे connectivity आ रहा है. So you have to see there is a flow and connectivity also in your answer. Now next what you can provide is the various case laws related to consideration, wherein what the courts have held with respect to consideration. So in that you can see I have mentioned over here in Curie versus Misa, the term consideration has been defined as some right, interest, profit or benefit occurring to one party or some forbearance, detriment, loss or responsibility given, suffered or undertaken by the other. Then in Fazluddin versus Panchu, the consideration is the price of the promise or written or quid pro quo, something of value received by the promisee as inducement of the promise. The payment of money is the most common form of consideration. देखो इस particular case law में कलकत्ता हाई कोर्ट ने हेल्प किया है कि पेमेंट ऑफ मनी जो है सबसे कॉमन फॉर्म ऑफ कंसिडरेशन है. एंड मैडम फैक्टम, you can highlight this over here, दैट मीन्स विदाउट कंसिडरेशन। अब आपने सिर्फ ये टर्म नहीं लिखा, आपने एक पर्टिकुलर वर्ड में उसको बता भी दिया कि व्हाट डज पैक्टम दैट मीन्स, दैट इज विदाउट कंसिडरेशन द प्रॉमिस इज नॉट enforceable. However sacred and binding it may be, it is after all purely gratuitous act and hence cannot create any legal obligation. So आपने देखा दो केस लॉज ऑलरेडी हमने बहुत प्रिसाइज वे में उससे रिलेटेड एस्पेक्ट कंसिडर्ड इन दीज पर्टिकुलर केसेस दैट हैज बीन प्रोवाइडेड ओवर हियर. नेक्स्ट अगेंस्ट कुमारी सोनी भाटिया वर्सेस स्टेट ऑफ उत्तर प्रदेश में हाउ कंसिडरेशन हैज बीन ऑब्जर्व, दैट basically means reasonable, equivalent or valuable benefit passed on by the promisor to the promisee or by the transferor to the transferee. So similarly, when the word adequate, it makes consideration stronger so as to make it sufficient and valuable having regards to facts, circumstances and necessities of the case. So आपने देखा body में अभी हमने क्या include किया, example, definitions, case laws, all those we have included with respect to the consideration. Next, essentials. So this is the second part of the body wherein we are talking about the essentials of consideration या कौन सी rules govern करते हैं consideration को. So from the above discussion about consideration and its definition under the Contract Act, the following are the essentials for a valid consideration. अब एक valid consideration के लिए क्या क्या चीजें important है हम उस सभी को present करने वाले हैं अपने आंसर के body में, and you have to ensure कि वो point wise है. आप देख सकते हो मैंने यहाँ point wise दिया है. So you can provide point number 1 as consideration must proceed at the desire of the promisor only. ये बहुत important है कि जो consideration flow करेगा किसी भी contract में, that should be proceeding at the desire of the promisor and it should not be at the desire of a third party because that is not being acknowledged as a consideration and that cannot be entertained by the court of law and so it cannot be made enforceable. In the case of Durga Prasad versus Baldev, which is one of the important case laws, what has been held, what was the facts, a brief about that, what the court actually held about the consideration and what was held in that particular case you have to mention. So the court held that the promise which is not supported by any consideration, there can be no recovery. तो आपने देखा बॉडी के पहले में भी हमने consideration से related case laws दिए थे. Then जब हम various essentials of valid consideration बता रहे हैं उसमें हमने जब points अपने देने हैं वहां पे भी हम include कर रहे हैं case laws को. Next is consideration may proceed from either the promisee or any other person. Another important aspect related to consideration है कि कंसिडरेशन जो है प्रोसीड कर सकता है, मूव कर सकता है आइदर प्रॉमिसी के एंड से भी या फिर किसी और पर्सन से भी, because it is not necessary for the consideration to follow from the promisee alone. Instead, it can proceed from any other person as well. इससे related case law है चिनैया versus रमैया. In this particular case, the court held that it is not necessary that the consideration must move from the promisee herself. This you can bold over here. This you can highlight over here. क्योंकि आपने इस केस के बारे में आपने पूरा यहाँ पे ब्रीफिंग दिया, बट इस पूरे ब्रीफिंग में जो भी डिटेल्स आपने दिए हैं इस केस से रिलेटेड सबसे इम्पोर्टेंट जो कोर्ट ने हेल्ड किया है वो यहाँ पे है. सो ओवर हियर यू कैन हाईलाइट दैट इट वाज हेल्ड बाय द कोर्ट दैट इट इज नॉट नेसेसरी दैट कंसिडरेशन विल बी मूविंग फ्रॉम द प्रॉमिसी ओनली. ठीक है. थर्ड पॉइंट इम्पोर्टेंट जो एसेंशियल्स है हमारा, दैट इज कंसिडरेशन कैन बी पास्ट, प्रेजेंट और फ्यूचर. सो कंसिडरेशन कैन बी इन एनी ऑफ दीज फॉर्म्स. इट कुड बी पास्ट, प्रेजेंट और फ्यूचर. The consideration of a contract may be an act or abstinence that has already been done at the desire of the promisor, is in progress or is promised to be done in future. On this basis, consideration can be categorized as these three. So you can see, मैंने इसको यहीं पे end कर दिया. Consideration के कितने categories है, past, present और future. You can also include in one point or 2 points, as in इसी particular point में consideration can be past, present और future. जब आप mention कर रहे हो कि ये 3 categories है, past, present और future, what does past consideration means? What does present consideration or what does future consideration means? You can include one point with respect to that also in your answer if the time permits and if you want to enhance your answer more. So that will convey to the examiner that you are aware of what these terms actually mean with respect to consideration. So elaboration you can do over here. Next important essential is consideration must be lawful in nature. So whatever consideration is involved in the contract, that has to be lawful. It must be legal in order for the agreement to stand. In this context, it would be appropriate to refer section 23 of the Contract Act, which states that consideration or object of an agreement is lawful until and unless what all it is forbidden by law is of such nature nature that if permitted, it would defeat the provisions of any law, fraudulent or involves or implies injury to the person or property of another, the court regards it as immoral opposed to public policy. अब यहाँ पे भी आप देखो कि ये मेरा सब पॉइंट था एसेंशियल्स में, पॉइंट नंबर 3. इसके अंडर में भी जब मैं सेक्शन 23 से रिलेटेड मैटर्स प्रेजेंट कर रही हूँ, आई हैव गिवन इट इन सब पॉइंट्स. सो पॉइंट्स, सब पॉइंट्स, सो इजी इट मेक्स टू रीड. अगर इसी को मैं कंटिन्यू करती, अनलेस इट इज फॉरबिडन कॉमा इज ऑफ सच नेचर कॉमा, वो आपका एक पूरा पैराग्राफ हो जाता. बट दैट वुडंट इफ वी टॉक अबाउट द अपीयरेंस वाइज, प्रेजेंटेशन वाइज, always writing in point wise is on a beneficial side. Okay, so except in situations when the illegal part of the agreement can be separated from the legal part, the entire agreement will be void if any part of it is illegal. In each of these cases, the consideration or object of the agreement is said to be unlawful, and every agreement of which the consideration or object is unlawful is void. यहाँ पे भी आप हाईलाइट कर सकते हो, इंपॉर्टेंट चीज है कि कोई भी कंसिडरेशन या ऑब्जेक्ट अगर unlawful है, that will be considered to be, the agreement will be considered to be a void one. There will be no valid contract between the parties. When the consideration or the object of an agreement is not lawful, the same will be termed as illegal contract. Okay, so ये पूरा हमने explain किया. और ज्यादा आप highlight कर सकते हो, underline कर सकते हो सब points में भी for better presentation. Now next point is continuing from the previous slide. We can also provide the information or detail, because we are saying for any contract the consideration is important for making it a valid one and all. But जो हमारा section 25 है contract act का, वो कहता है as a general rule declares that an agreement without consideration is void. However, mentions certain exceptions. So section 25 of the contract act को हम present कर सकते हैं, यहाँ पे involve कर सकते हैं, because that not only is providing that an agreement without consideration is considered to be a void one. However, as a general rule, this has been provided in that section, but it also provides certain exceptions where if there is no consideration, then also the contract will be considered to be a valid one. So an agreement made without consideration is void until and unless these things actually are there. It is in writing and registered, and it is on account of natural love and affection between the parties standing in near relation to each other. It is a promise to compensate for something done by any person voluntarily for the promisor, or which the promisor was legally compellable to do, and it is a promise to pay a debt barred by limitation law. It is a promise which is made in writing and signed by the person to be charged therewith or by his agent to pay wholly or in part a debt of which the creditor might have enforced. In any of the above situations, an agreement is a contract. So general rule जो section 25 state कर रहा है, वो क्या है हमारा, यहाँ पे आप highlight कर सकते हो. This is the general rule which says agreement without consideration is void. Then you can mention that to this general rule there are certain exceptions wherein no consideration, even if it is present, the contract is a valid one. And then यहाँ पे हमने इसका section 25 से related एक concluding point दिया कि in any of the above three situations an agreement is considered to be a contract, even though वहाँ पे consideration involved नहीं था. Then consideration doesn't necessarily have to be adequate in nature. So adequacy of the consideration is not important. That is one of the essentials. It must be of some value, although it has not to be necessarily adequate. Consideration must have some value in the eyes of the law. In Chidambra Iyer versus P.S. Renga Iyer, it was held that consideration shall be something which not only the parties regard, but the law can also regard as having some value. Adequacy जरूरी नहीं है, but अगर वो कुछ value का है, if it is of some value in the eyes of the law or the parties entering into a contract, then also it will be considered to be a valid one. Consideration must be real in nature and not impossible or illusionary. This is another important. So आप देख सकते हो सारे सब points को मैंने highlight किया है. सब points के अंदर भी आप highlight कर सकते हो, which I am telling you over here. Then consideration must be real. It should not be physically, legally impossible in nature. The consideration will not be considered real if it comes with a level of uncertainty if it is involved there, because consideration, if it is not certain, it becomes impossible to carry it out. The impossibility can be legal, physical, and can be illusionary consideration. And ये हमारा body end हुआ. And now जितना भी अभी हमने आंसर में लिखा था, हम उसका conclusion provide करेंगे. And that you can see. Thus, from the above discussion, it can be concluded that consideration as defined under the contract act forms an essential part of a contract to be a valid one. This you can highlight. It is essential because it creates an obligation on both the parties to the contract to fulfill their respective promises. And if it is not present, then the burden on the parties may not be enough to ensure the completion of the contract. All these things we have concluded. Further, we mentioned that consideration being an essential element of a valid contract should be present in any contract, as any contract without consideration will be making it void, and this cannot be enforced. Consideration may be an act done in the past, present, or future. When the contract is entered, there must be a valid consideration, adequacy of which is immaterial. However, it should be valuable according to the parties to the contract or in the eyes of the law. So this is how you need to conclude your answer. So stay tuned to our channel for further discussions with respect to the judiciary descriptive main answer writing practice, and apart from that, other videos with respect to the content, the mock test series which we are continuing and providing you. So do remember to subscribe to the channel, stay tuned and stay updated, and make your preparations 50% faster with us at iExamB.